Have you ever had to deal with an incessantly noisy neighbor or other disruptive circumstances? When it happens, it creates a sometimes hostile but always unenjoyable experience. For landlords, handling complaints from tenants may bring up the phrase covenant of quiet enjoyment. Although it may sound obscure, this legal standing is critical for both landlords and tenants to understand. In this video, we help explain a tenant's right to quiet enjoyment along with what a breach of quiet enjoyment can mean for your rental property. Hey everyone, it's Alyssa here from Bay Property Management Group. Before we get started, be sure to subscribe and hit that notification bell so you never miss out on our exclusive content. With that said, let's jump into today's video. Let's start with the basics. So what is the covenant of quiet enjoyment? Broken down, this promises that individuals can reside in a property peacefully, without undue disturbance from others. That said, quiet enjoyment does not just relate to the obvious peace and quiet complaints. It also implies the right to exclude individuals from the premises, to have clean premises, and the right to essential services such as heat and hot water. Therefore, many landlords compare it to the more familiar warranty of habitability that dictates owners must keep the property in good repair. It is important to note that courts recognize this covenant as a given part of a tenancy in the landlord-tenant relationship. Furthermore, this covenant cannot be waived for residential rental agreements, so a tenant has the right to quiet enjoyment regardless of whether the lease specifically speaks to it or not, otherwise known as an implied covenant of quiet enjoyment. Definitions of what qualifies as quiet enjoyment are likely to differ from one person to another. Unfortunately, courts don't always help provide clarity, as anything from drug activity to a noisy smoke alarm can affect peaceful habitation. Therefore, the lesson is that the complaint does not have to be extreme for the court to agree with the tenant. So let's check out a few examples of what constitutes a breach of quiet enjoyment. The right to privacy. This means the landlord may not enter the premises without permission, except in the event of a true emergency when efforts to reach the tenant have failed. Additionally, property owners cannot tamper with a tenant's mail or conduct surveillance on the tenant. Restrictions deemed unreasonable. Tenants have the right to enjoy the property they lease, meaning as long as it does not violate the provisions of the lease, tenants may use the property how they see fit. A common dispute between landlords and tenants is over the guest policy. But keep in mind, a renter is allowed to host guests and even small gatherings on occasion. That said, if landlords try to restrict a tenant's use unreasonably, it may constitute a breach of quiet enjoyment. Absence of basic services. When utilities are included or the landlord is responsible for payment and fails to do so, this is a major issue. In addition to affecting habitability, it also allows the tenant an opportunity to claim breach of quiet enjoyment. Landlords may shut off utilities temporarily for safety when a necessary repair is needed. However, the time must be as brief as possible and tenants should be notified in advance. Here are a few additional examples of disturbances to quiet enjoyment. Frequent or unnecessary inspections of the property, landlord harassing a tenant or tenant's guests in person or on the phone, unnecessarily remodeling work or maintenance that takes an unreasonable amount of time, vermin or pests in the walls making disruptive noises. On the flip side, there are times where disturbances are acceptable, including scheduled maintenance or repairs with proper notice, routine inspections as outlined in the lease agreement or with proper notice, emergency maintenance or repairs, common wildlife or traffic noise outside, footsteps from neighbors in common areas or above a tenant, a smoke alarm going off that is turned off right away. A common question is, what about noisy neighbors? Is that breach of quiet enjoyment? Well, that depends. For tenants living in a multifamily building, complaints against neighbors are an easy subject to approach. Landlords must take action to address the issue with both tenants to come to an agreeable resolution. That said, it is a different story if the nuisance generates from outside the property. Some laws protect a landlord from breach of quiet enjoyment if they have no control over the source. So the circumstances must be within the landlord's control and fall within their natural scope of landlord duties to be held responsible. For instance, landlords can pursue eviction for a perpetually disruptive tenant in a property they own. However, a landlord has no rights against any breach of quiet enjoyment stemming from a neighboring property owned by someone else. Typically, tenants will have to rely on local law enforcement for complaints against individuals not under the landlord's control. Not every complaint about breach of quiet enjoyment ends up in court. More commonly, these issues get solved through proper and professional communication. To best handle a complaint when it arises, landlords must understand their tenants' rights. So let's take a look at the process of resolving a breach of quiet enjoyment complaint. Step 1. The tenant submits a breach of quiet enjoyment complaint in writing. As with all landlord-tenant communication, it is imperative to retain a written record of the interaction. This helps mitigate the threat of any disputes or misunderstandings in the future. First off, tenants must submit a covenant of quiet enjoyment letter to inform the property owner that a breach of quiet enjoyment has occurred. It is important that this letter provide as much detail as possible on how the incident affected their living situation. Next up, when a complaint is received, the landlord must promptly investigate and attempt to resolve the issue before it escalates. Step number 2, landlords must respond to the complaint. Once notification has taken place, the ball is in the landlord's court. Just as the tenant submitted a complaint in writing, that is how the landlord must respond, which creates an essential communication trail. This response should inform the tenant of the steps you are taking to resolve the issue, as well as an estimated time frame for these steps to take place. As always, transparent communication is an essential part of ensuring a tenant's satisfaction. Step number 3, withholding rent payments. If there is a significant issue that is not resolved promptly, the tenant may have the right to withhold rent. Local laws will provide guidance on if or under what breach of quiet enjoyment circumstances a tenant can withhold their rent. However, it is in the landlord's best interest to address the tenant's complaint as quickly as possible to avoid this from happening. Even if fixing the situation will take time, communicate with your tenants every step of the way so they know you are taking their concerns seriously. Step number 4, the tenant has the option of a constructive eviction. When all else fails, a tenant can voluntarily evict themselves, otherwise known as a constructive eviction. However, this is not a common occurrence, and all parties must understand that this is only valid for the most severe of issues. For example, a property's owner repeatedly refusing to remediate mold in the home. Generally, these escalated complaints also infringe on the tenant's warranty of habitability in some way. Also, the tenant may still risk losing their security deposit or be responsible for unpaid rent. Ultimately, the court will look at whether the tenant provided proper notice of the problem and what steps the landlord did or did not take. So always keep records of any communications with your tenant and retain evidence of any actions you took on their behalf to preserve their right of quiet enjoyment. And finally, step number 5, taking the matter to court. When a tenant and landlord simply cannot reach a reasonable resolution to the complaint, they may find themselves in court. As with any legal process, landlords must have their documents and evidence in order to avoid possible lawsuits. Common reasons a complaint may escalate to small claims court include the landlord withholds the tenant's security deposit after a constructive eviction, a landlord is seeking unpaid rent, or the tenant claims a broken covenant of quiet enjoyment without reason. No one wants to handle disruptive circumstances or a breach of quiet enjoyment complaint. However, knowing your rights and that of your tenant helps to navigate even the most intense situations. For more advice on a variety of other issues important to the rental industry, subscribe to the Bay Property Management Group channel, and don't forget to hit the notification bell so you never miss out on our exclusive content. Also, be sure to check out our blog via the link in the description below for tips on landlord-tenant law, along with everything from resolving conflicts to home maintenance advice. If you liked this video, please give it a thumbs up or leave a comment down below. Thanks for watching, and we will see you in the next video.